Good morning, class. Settle down, please. Settle down. Right, today we're dissecting an absolutely critical topic for your upcoming Karnataka State Law University examinations. We are looking at question 16, Define Wakf, Essentials and Kinds of Wakf. Now listen to me. This is a standard, recurring 16-mark question. I'm going to give you the exact blueprint for it today. I expect you to note down this precise structure, literally word for word, if you want to secure maximum marks. Pay strict attention because, as you know, an unstructured answer in a law paper is a useless answer.
Here is our agenda, which is exactly the synopsis you must write at the top of your answer sheet before you even begin your essay. Section 1, Introduction and Definition. Section 2, Essentials of a Valid Wakf. Section 3, Landmark Case Laws. Section 4, Kinds of Wakf. Section 5, Legal Characteristics. And finally, Section 6, Conclusion.
Let's start with Section 1, Introduction and Definition. Make sure this heading is underlined twice on your script. Write this exact opening paragraph. Under Muslim law, Wakf is a permanent dedication of property for religious, pious, or charitable purposes, transferring ownership to God for societal welfare. Okay, stop writing for a second and just listen. This sets the absolute foundation of the legal concept. It simply has to be the very first paragraph you write. It tells the KSLU evaluator right away that you clearly understand the dual nature of Wakf, the divine ownership aspect and the practical earthly benefit, which is societal welfare. Now for the formal definition. Wakf is a permanent dedication of movable or immovable property by a Muslim for purposes recognized by Muslim law as religious, pious, or charitable. Let's strictly dissect these key words because this is exactly what the examiner is scanning your paper for. First, permanent. It absolutely cannot be for a temporary term of years. Second, dedication, meaning a complete, irrevocable giving up of rights. And finally, recognized by Muslim law. So not just any charity, but one specifically recognized by the faith. Highlight these exact words in your exam. Moving on to Section 2, Essentials of a Valid Wakf. I'm warning you right now, missing even one of these upcoming 7 essentials will result in a heavy loss of marks. They are cumulative. Every single one must be present for the Wakf to stand in the eyes of the law. Point 1, permanent dedication. It must be permanent and irrevocable. Temporary is invalid. Point 2, competency of the Wakif. They must be a major, of sound mind, and the owner of the property. Now let's elaborate on this deliberately. Why does a temporary Wakf fail in law? Because you cannot temporarily transfer ownership to the Almighty. Once given, it's gone forever. If someone says, I dedicate this land for 20 years, that is void ab initio. Secondly, the Wakif, the person making the dedication, must have strict legal competency under the Indian Majority Act. It's an absolute legal necessity. If the Wakif is a minor or of unsound mind, the whole dedication is null and void. Continuing with the essentials. Point 3, ownership of property. It must belong to the Wakif, whether it's movable or immovable. Point 4, the purpose must be religious, pious, or charitable, such as a mosque, education, or relief to the poor. Remember the strict rule of property jurisprudence, class, nemo.quod non habet. You cannot give what you do not have. One cannot dedicate property they don't perfectly own. And regarding the purpose, you must write down these specific examples on your paper: mosque, education, and relief to the poor. Don't use vague terminology, use the exact categories recognized by the law. And the final 3 essentials. Point 5, declaration of Wakf. There must be clear intention, which can be oral or written. Point 6, no need for acceptance, unlike hiba. And point 7, transfer of ownership to God, meaning the Wakif loses all control. I really need to emphasize this to the entire classroom. Pay close attention to point number 6. In the concept of hiba, or a gift, acceptance by the donee is absolutely mandatory. But in Wakf, acceptance is not needed at all. Why? Because as point 7 clearly lays out, ownership unequivocally vests in God Almighty. The Wakif is stripped of all worldly control the very second the declaration is made. Note this distinction clearly, as it's a favorite trap for examiners. Section 3, Landmark Case Laws. Get your pens ready. Put your pens down for just a second and listen to me very carefully. An answer in a KSLU law paper without proper case law citations is basically an incomplete high school essay. To secure those full 16 marks, you must back up your theory with judicial precedent. You will cite MST Puran Sahib v. Mohad Hussain, where the court held that Wakf must be permanent and irrevocable, otherwise it is invalid. On your exam sheet, I want you to draw a distinct box around this exact case name. Let's break the facts down. The brief background of this matter revolved around a dedication made with strings attached. The donor attempted to retain the power to revoke the charity if their circumstances changed. The ratio decidendi, the strict legal reasoning of the court, was that the very essence of Wakf is perpetuity. The moment a revocation clause is inserted, the dedication is legally dead. The absolute relevance of this case is that it completely and unequivocally validates our first essential condition, permanent dedication. If you want a 16-mark answer, this goes in a box. Your next citation is Abdul Fattah Muhammad Ishaq v. Rasamoy Dur Chowdhury. Here, the Privy Council laid down principles regarding the validity of Wakf and emphasized the need for a genuine charitable purpose. I want you to heavily underline this citation to capture the evaluator's attention immediately. The factual background here is monumental. It dealt with family settlements where wealthy individuals tried to tie up their property in perpetuity for their own descendants, creating a highly remote, illusory gift to the poor only after their entire family line went extinct. The Privy Council's final verdict struck this down completely. The ratio decidendi established that a Wakf for family is invalid if the ultimate gift to charity is merely an illusion designed to circumvent property laws against perpetuities. There must be a genuine, substantial charitable purpose. This case is the absolute cornerstone of understanding the necessity of lawful purpose in Wakf. Make sure you write it down.
Let's transition to Section 4, Kinds of Wakf. Write this heading in bold letters.
List these out clearly. 1. Public Wakf, created for the general public, like mosques, schools, and hospitals. 2. Private Wakf, known as Wakf Alal Alad, created for family members, but the ultimate benefit must go to charity. You need to clearly distinguish between a public Wakf and Wakf Alal Alad. I am drilling this into you right now. A private Wakf, established for the maintenance of one's own children and descendants, is legally recognized, but it is only valid if the ultimate, final benefit inevitably and expressly goes to an enduring charity once the family line extinguishes. If that ultimate charitable remainder is missing, the private Wakf is entirely void. Next, 3. Wakf by user, created through long, continuous use, for example, land used as a mosque for years. And 4. Conditional Wakf, subject to conditions that must not violate the principles of Wakf. Let me give you a comprehensive explanation of Wakf by user, because this is a highly scoring point to explain on the exam. You see, sometimes there is no written deed or formal declaration. But if a piece of land has been continuously used as a mosque or a graveyard by the community since time immemorial, the law creates a legal fiction of dedication. The continuous user itself proves the Wakf. Note that down. The examiner will actively look for the phrase legal fiction.
Moving to Section 5, Legal Characteristics of Wakif. Create a brief, separate subheading for these traits right before your conclusion. It demonstrates total, organized mastery of the topic to the examiner. List them as irrevocable, perpetual, inalienable, and managed by mutawali. The first 3 words neatly summarize everything we've discussed so far. But look closely at that last point. You must clearly define for the examiner that the mutawali is strictly a manager, a superintendent of the property. The mutawali is never, ever the owner. Ownership, as we established in the essentials, has permanently shifted to God. Mark my words, if you write that the mutawali owns the property, you will fail the question.
Finally, Section 6, Conclusion. A structured legal essay in KCLU must always, without exception, end with a formal, summarizing conclusion. Don't just trail off and leave the examiner hanging. Write this exactly. Wakf is an important institution in Muslim law promoting charity. Its validity depends on permanent dedication and lawful purpose, becoming irrevocable and ensuring continuous societal benefit. This paragraph is brilliant because it perfectly ties together the religious intent and the rigid legal execution. It summarizes the permanent dedication and the lawful purpose, leaving the evaluator with a clear, concise final thought for a flawless 16-mark finish.
So, the final question is, are you prepared to replicate this exact blueprint to secure maximum marks on your KSLU examination? Law is about discipline, it's about structure, and it's about precedent. If you deviate from this rigidly formatted structure, you do so entirely at your own peril. Memorize these headings, practice writing those case laws in the boxed formats we discussed, and reproduce this exact logical flow in your upcoming term-end exams. Prepare diligently. Class dismissed.